Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute professional financial, legal, or tax advice. Every individual's financial and legal situation is unique, and the laws governing the division of assets vary significantly by state and jurisdiction. You should not act or rely upon any information in this video without first seeking the advice of a qualified professional, such as a certified financial planner, a family law attorney, or a tax expert. We strongly encourage all viewers to conduct their own due diligence and consult with licensed professionals before making any decisions regarding retirement accounts or legal settlements. Imagine spending 30 years of your life building a fortress of financial security. You have diligently deferred a percentage of every paycheck, captured every employer match, and watched the power of compound interest turn a modest monthly contribution into a seven-figure 401k. You are ready for the American dream. The travel, the hobbies, the peaceful transition into your golden years. Then the unthinkable happens. You receive a legal notice that doesn't just end your marriage, but effectively cleaves your life's work in half. In the United States, this is not a rare tragedy. It is a statistical reality. While many people focus on who gets the house or the car, the real war is often fought over the most boring-sounding document in the legal system: the Qualified Domestic Relations Order, or QDRO. This single piece of paper determines if you will retire in comfort, or if you will be forced back into the workforce at age 70. In this deep dive masterclass, we are pulling back the curtain on the cultural and financial phenomenon of the 401k divorce. We are exploring why modern American pop culture has become obsessed with the high-stakes drama of asset division, how the legal system actually handles your retirement eggs, and the specific case studies that show how million-dollar portfolios can vanish overnight through simple administrative errors. For the average American household, a 401k is often the single largest asset outside of home equity. Yet, in our popular media, from the ruthless legal battles in HBO Succession to the comedic but cautionary tales in films like It's Complicated, we see a recurring theme: the shock of the split. This video solves the fundamental problem of financial blindness during a domestic transition. You will learn the historical trends of how retirement assets became the primary battlefield of the American divorce court, the intricate mechanics of community property versus equitable distribution, and the exact step-by-step process used by professionals to shield or divide these accounts without triggering massive IRS penalties. This is part 1 of our 10-part series, and today, we are setting the foundation by examining the intersection of the American retirement system and the legal realities of a broken contract. To understand the 401k divorce, we must first look at the data. In 2025, the American Psychological Association and various legal research organizations reported that approximately 41% of first marriages in the United States end in divorce. While that number is a gradual decline from the peak highs of the 1980s, the financial stakes have actually increased. Why? Because Americans are marrying later in life. In decades past, couples often started with nothing. Today, individuals are entering marriages with established careers and growing retirement accounts. When these marriages dissolve, they aren't just dividing a shared checking account. They are litigating over decades of accrued compound interest. Historical trends show that for second marriages, the divorce rate jumps to roughly 60%, and for third marriages, it climbs above 70%. Each subsequent marriage represents a higher risk to the principal of a 401k. Plus one. Consider a typical case study. A couple in their mid-50s, living in a community property state like California or Texas, decides to part ways. The primary earner has a 401k valued at $1.2 million. In a community property state, any contributions made to that account during the marriage, along with the growth on those specific contributions, are considered shared property. It does not matter whose name is on the account. It does not matter who did the work to earn the money. The law views the marriage as a single economic unit. If they were married for the entire duration of the account's growth, that $1.2 million is effectively $600,000 for each party. This is where pop culture often gets it wrong. Movies depict dramatic scenes of spouses taking the money, but in reality, the process is a surgical, bureaucratic procedure governed by federal law. The central mechanism of this division is the Qualified Domestic Relations Order, commonly known as a QDRO. You can think of a QDRO as a special legal key that unlocks the 401k without breaking the tax rules. Normally, if you take money out of a 401k before age 59.5, the IRS hits you with a 10% early withdrawal penalty plus standard income tax. However, A QDRO allows for a transfer incident to divorce. This means the money can move from one spouse's 401k into the other spouse's IRA or 401k without that 10% penalty. This is a critical distinction that many unrepresented individuals miss, leading to potential outcomes where a significant portion of the settlement is lost to the government before it ever hits a bank account. +3. In American pop culture, we see the emotional weight of this played out in shows like The Good Wife or Billions, where the retirement play is used as leverage. The narrative often frames the retirement account as a nest egg, a symbol of safety and the future. When that egg is cracked, it signifies more than just a loss of dollars. It signifies the loss of the rest of your life. We see this in the 2026 cinematic landscape as well, where gray divorce among those aged 50 and older, is becoming a dominant trope. The reality is that for people in this demographic, there is no time left to recover from a 50% hit to their retirement. If you are 30, you can rebuild. If you are 62, a 401k divorce can mean the difference between a private assisted living facility and relying entirely on Social Security. The complexity deepens when you factor in employer contributions and vesting schedules. Let's look at the Round 1 entertainment case study, a common example used in legal training. If an employee has a 401k where the employer matches 5%, but those matches don't vest, meaning the employee doesn't fully own them, for 5 years, the court must decide how to value the unvested portion. If the divorce happens in year 4, is the spouse entitled to half of the potential match? This is where forensic accountants enter the picture. They must calculate the present value of future assets. In the high-stakes world of U.S. corporate divorce, these calculations can take months and cost tens of thousands in legal fees, often eating into the very 401k they are fighting over. Another significant cultural shift is the rise of the self-directed 401k, or solo 401k, among the American workforce's growing freelance and entrepreneur class. Unlike traditional corporate plans, these accounts often hold non-traditional assets like real estate or private equity. When these are part of a divorce, the valuation becomes a nightmare. Pop culture loves the drama of a hidden asset, but in a 401k divorce, everything is tracked by the Department of Labor and the IRS. There is a paper trail for every cent. The drama isn't in finding the money. The drama is in the math of the split. As we move through this series, we will break down the specific legal hurdles of ERISA, the Employee Retirement Income Security Act, which is the federal law that trumps state law when it comes to your 401k. We will look at why a prenuptial agreement might not always protect your 401k as much as you think it does, and why your choice of a plan administrator might be the most important financial decision you never knew you made. The goal of this masterclass is to move past the sensationalism of Hollywood and into the rigorous reality of the American financial system. Whether you are currently married, considering divorce, or just starting your career, understanding the 401k divorce is essential because, in the eyes of the law, your retirement is not just yours, it is a shared legacy of a legal contract. To understand why the 401k has become such a polarizing symbol in American pop culture, we have to look at the transition from the traditional pension to the era of individual responsibility. In the mid-20th century, the American dream was anchored by the defined benefit plan. You worked 40 years for a single company, and upon retirement you received a check every month for the rest of your life. In that era, divorce was certainly a financial blow, but the pension was a stream of income that was relatively straightforward to divide. Fast forward to 2026, and that world is gone. We are now in the age of the defined contribution plan, specifically the 401k. This shift changed the psychology of marriage and divorce in America. Now the retirement account is a giant visible pile of cash, often sitting in an app on your phone. You see it every day. You watch the market fluctuations. Feels deeply personal. Feels like your individual effort. So when a legal system steps in to split that pile in two, the psychological impact is far more visceral than splitting a future pension check. Imagine a character named Sarah, a software engineer in San Francisco. It is 2026, and Sarah has spent the last 15 years maximizing her 401k contributions, taking advantage of every catch-up contribution allowed by the IRS. She marries Mark, who has a more erratic career path in the gig economy. In Sarah's mind, that 401k is her safety net, her achievement, and her identity. But under the laws of most states, the moment she says "I do," the character of that account begins to change. Every dollar she contributes from her salary during the marriage, and more importantly, the growth on the entire balance during those years, becomes marital property. If the marriage lasts 10 years and the market performs well, a significant portion of that $1 million account is now legally half Mark's. Pop culture often portrays this as a shock or a betrayal, but it is actually the standard application of American family law. In movies like Marriage Story or even the more satirical portrayals in shows like White Lotus, we see the tension that arises when one partner realizes their financial future is tethered to a relationship that is ending. The 401k is no longer just an investment account, it is a point of leverage. We see characters using the threat of a QDRO to negotiate for the house or for custody arrangements. This brings us to a critical step-by-step reality of how this asset is actually valued during a U.S. divorce in 2026. The process usually begins with a request for a summary plan description and the most recent account statements. But the statement balance is rarely the final number used for division. Attorneys must determine the coverture fraction. This is a mathematical formula used to separate the separate property, what you had before the wedding, from the marital property, what was earned during the marriage. Let's look at a case study involving a high-earning executive in Chicago named David. David entered his marriage with $200,000 in his 401k. 10 years later, at the time of his divorce filing in 2026, the account is worth $800,000. It is a common misconception that the spouse is entitled to $400,000. In reality, the court must account for the passive appreciation of that original $200,000. If the market doubled during those 10 years, $400,000 of that final balance might be considered David's separate property, leaving only $400,000 to be split. This is where things get incredibly expensive. If David cannot produce the statements from 10 years ago to prove his starting balance, the court may default to assuming the entire $800,000 is marital property. In the American legal system, the burden of proof for separate property lies with the account holder. This historical trend of poor record-keeping has led to what some experts call the record-keeping tax, where individuals lose hundreds of thousands of dollars simply because they didn't save a PDF from a decade prior. Pop culture frequently glosses over the administrative nightmare that follows the judge's signature. In a 2026 legal drama, you might see a judge bang a gavel and say she gets half the 401k. End of scene. In reality, that is just the beginning of a months-long bureaucratic marathon. The 401k is not governed by the divorce decree alone. It is governed by ERISA, a federal law that is notoriously rigid. The plan administrator, the person at the company or the financial institution managing the funds, has the final say on whether a QDRO is qualified. If the wording is slightly off, if a comma is in the wrong place, or if the math doesn't align with the plan's specific rules, the administrator will reject the order. During this time, the market doesn't stop. If the order specifies a dollar amount rather than a percentage, and the market crashes while the paperwork is being processed, the person receiving the funds might end up with a much larger share of the remaining pie than intended. Conversely, if the market moons, they might get far less than they expected. This leads to the concept of the valuation date, a recurring theme in high-stakes financial litigation. Does the spouse get half the value of the account on the day of the separation, the day of the filing, or the day the transfer actually occurs? Historical trends in 2026 show that this single detail can result in a swing of tens of thousands of dollars. Imagine if the valuation date was set for early 2020 right before a major market dip, but the transfer didn't happen until late 2021 after a massive recovery. The disputes over these windows of time are what keep divorce attorneys in business for years. Furthermore, we must address the 401k loan, a feature of American finance that often acts as a landmine in divorce settlements. Many Americans use their 401k as a personal bank, taking out loans for home down payments or debt consolidation. In a divorce, a 401k loan is often treated as an advance on the person's share of the asset. If James has a $100,000 401k but took a $30,000 loan to pay off credit cards, the court may value the account at the full $100,000. If his spouse is awarded 50%, she gets $50,000, leaving James with only $20,000 in actual cash after the loan is accounted for. Pop culture rarely shows the math, but the math is where the tragedy often lies. The cultural fascination with the 401k divorce also stems from the rising phenomenon of the silver splitter. Americans over age 50 are divorcing at double the rate they were in the 1990s. For this demographic, the 401k isn't a theoretical future. It is their immediate survival. We are seeing a trend where the 401k is being traded for other assets in a process called offsetting. A spouse might say, you keep your $500,000 401k, and I will keep the $500,000 in home equity. On the surface, this looks like a clean break. But in 2026, savvy viewers and financial experts know this is often a trap. The $500,000 in the house is post-tax equity. The $500,000 in the 401k is pre-tax money. When that 401k is eventually withdrawn, it will be taxed as ordinary income. A person who trades a house for a 401k of equal face value is effectively taking a 20% to 30% loss the moment the deal is signed. This hidden tax liability is the silent killer of many American divorce settlements. As we peel back the layers of this financial onion, we start to see that the 401k is more than a fund. It is a complex legal entity that requires precision to handle. But what happens when there are multiple 401ks from different employers? What happens when one of those employers no longer exists, or the plan has been merged into another? The hunt for zombie 401ks is a growing subgenre of American financial recovery. And perhaps most importantly, what are the specific traps that can lead to an immediate, irreversible IRS audit during a split? We have established the psychological weight and the basic legal framework, but the real danger lies in the execution. In the next part, we are going deep into the mechanics of the QDRO itself. We will examine the specific language that can make or break a settlement, the role of the plan administrator as the ultimate gatekeeper, and the nightmare scenario of the non-cooperative spouse who tries to drain the account before the freeze is put in place. If you think a judge's signature is the end of the story, you are about to see why the paperwork after the divorce is often more dangerous than the trial itself. The courtroom drama might end with a gavel, but the real financial surgery happens in the quiet offices of plan administrators. We have to address the myth of the automatic split. Many Americans believe that once a judge signs a divorce decree stating that assets are to be divided 50-50, the work is done. In reality, a divorce decree is almost entirely useless when it comes to a 401k. This is because of the federal supremacy of ERISA. Most retirement plans are governed by federal law, not state law, and plan administrators are legally prohibited from following a state court order, unless it is specifically drafted as a qualified domestic relations order. This document, the QDRO, is the only bridge between the state court and the federal retirement system. If you fail to secure a separate, approved QDRO, you could walk away from a 10-year marriage with a signed judgment and $0 in retirement assets. Imagine a character named Michael in 2026. Michael is a project manager in Atlanta who has been married to Jennifer for 12 years. Their divorce is relatively amicable. The judge signs off on a settlement that awards Jennifer 50% of Michael's 401k, which is currently valued at $600,000. Jennifer takes her signed decree and moves on with her life, assuming the money is hers. 3 years later, Michael unexpectedly passes away. When Jennifer contacts the 401k provider to claim her $300,000, she is met with a devastating reality. Because Michael never remarried and Jennifer was still listed as the beneficiary on the account, but no QDRO was ever filed or approved, the plan administrator might be legally obligated to pay the entire balance to Michael's estate or his secondary beneficiaries according to the strict terms of the plan. This is a recurring case study in American probate law. The divorce decree did not change the ownership of the account in the eyes of the plan. Only a QDRO can do that. The step-by-step drafting of a QDRO is where most of the potential outcomes are decided. It is not a fill-in-the-blank form. Each 401k plan has its own unique set of rules, often referred to as the plan document. Before a lawyer even drafts the order, they must request the specific QDRO procedures from the employer. Some plans allow for a separate interest approach, where the account is physically split into two separate accounts immediately. Others use the shared payment approach, where the non-employee spouse only receives their portion when the employee spouse actually begins taking distributions. In pop culture, we see the former as the ideal, but in the gritty reality of 2026 corporate America, many older or more restrictive plans only allow for the latter, forcing ex-spouses to remain financially tethered for decades. Let's look at the historical trends of the non-cooperative spouse, a trope we see frequently in American media like Succession or various legal thrillers. In these scenarios, one spouse realizes that the divorce is imminent and attempts to drain the 401k before a freeze can be implemented. Imagine if Robert, a high-net-worth individual in New York, decides to take a massive loan against his 401k or change his investment strategy to high-risk options the moment he senses his spouse, Linda, is filing for divorce. In the U.S. legal system of 2026, most states have automatic temporary restraining orders that go into effect the moment a divorce is filed. These orders legally prevent either party from making extraordinary expenditures or changing the nature of retirement accounts. However, there is often a gap between the intent to file and the actual service of papers. If Robert liquidates or takes a loan during this window, the court might view this as a dissipation of marital assets. The consequences of dissipation are severe. If a judge determines that one spouse intentionally depleted a 401k to keep it out of the hands of the other, the court can award the innocent spouse a larger share of the remaining assets to make them whole. For example, if Robert spent $50,000 of marital funds on a luxury vacation with a new partner, the court might deduct that $50,000 entirely from Robert's half of the remaining 401k. This creates a high-stakes game of financial forensics. In 2026, digital footprints make it nearly impossible to hide these transactions. Yet we still see case studies where individuals attempt to use 401k hardship withdrawals as a way to hide cash. The IRS defines hardship withdrawals very strictly: medical expenses, funeral costs, or preventing eviction. Using a hardship withdrawal as a divorce tactic is a fast track to both a tax penalty and a contempt of court charge. Another critical layer is the role of the alternate payee. In QDRO terminology, the spouse receiving the funds is the alternate payee. This person has a unique, one-time opportunity that is often overlooked in popular financial advice. Under Section 72(2)(c) of the Internal Revenue Code, if you receive a distribution from a 401k via QDRO, you can actually take the cash out immediately without the 10% early withdrawal penalty. Even if you are under age 59.5, you still have to pay ordinary income tax, but the penalty is waived. This is a massive piece of leverage for a spouse who needs immediate liquidity to buy a new home or pay for legal fees. However, this only applies if the money is taken directly from the 401k as part of the QDRO. If the alternate payee first rolls the money over into their own IRA and then tries to withdraw it, the 10% penalty is reinstated. This is a historical trend where a lack of specific tax knowledge leads to a 10% loss on hundreds of thousands of dollars. Consider the case of Maria in 2026, who was awarded $200,000 from her ex-husband's 401k. She needed $50,000 for a down payment on a condo. Her brother, a well-meaning but non-professional advisor, told her to roll the whole $200,000 into an IRA first to keep it safe. She followed his advice, then withdrew the $50,000 from the IRA. Because she moved the money to an IRA first, she lost the QDRO penalty protection. She was forced to pay a $5,000 penalty plus taxes, a loss that could have been completely avoided with the correct step-by-step execution of the distribution. Pop culture rarely focuses on the tax code, but in a deep dive masterclass, we recognize that the tax code is where the real winners and losers are determined. There is also the issue of plan fees and market volatility during the period of segregation. Once a plan administrator receives a draft QDRO, they typically place a hold on the account. This hold prevents loans or withdrawals, but it does not always prevent the account holder from changing the investment allocations. Imagine a scenario where the 401k is invested in a volatile tech sector. The divorce process takes 18 months. During those 18 months, the market swings 30% in either direction. If the QDRO specifies that the alternate payee gets a fixed dollar amount, say $100,000, and the account drops from $200,000 to $110,000, the original account holder is left with almost nothing. If the QDRO specifies a percentage, both parties share the market risk. In 2026, most professional QDRO drafters insist on percentage-based splits with pro rata gains and losses to ensure that the intent of the court is preserved regardless of market timing. We have explored the paperwork, the penalties, and the tactical errors that can devastate a retirement plan. But what happens when the 401k is just one piece of a much larger puzzle involving stock options, restricted stock units, and deferred compensation? In the American corporate landscape, the 401k is often the simplest asset. The real complexity, and the real drama, begins when we look at the executive compensation packages that dominate the storylines of shows like Industry or Billions. How does the legal system handle a 401k when it is tied to a company that is about to go public or one that is facing a federal investigation? We are just beginning to see how deep this rabbit hole goes. While the QDRO is the tool for the 401k, there are entire classes of retirement assets that a QDRO cannot touch. In the next part, we will pivot to the shadow side of retirement divorce: non-qualified plans, the hidden traps of the 403b, and the specific challenges faced by public sector employees whose pensions follow entirely different rules than the 401k. If you think you understand the split because you understand the 401k, you are missing half the map. We are going to look at the assets that legal teams often forget to mention until it is too late. The standard 401k is the visible tip of the iceberg, but as we move into the deeper waters of American executive and public sector life in 2026, we encounter the shadow assets that often dictate the true power balance in a divorce. While the 401k is a qualified plan, many high earners in corporate America participate in non-qualified deferred compensation plans, often referred to as top hat plans. These are the assets you see discussed in hushed tones in boardrooms on shows like Succession. The critical difference here is that these plans are not governed by ERISA. This means the QDRO, the very tool we just mastered in the previous part, is completely powerless here. You cannot use a QDRO to divide a non-qualified deferred compensation plan. Instead, these assets must be handled through a standard domestic relations order or, more commonly, through a complex process of offsetting other marital assets. Imagine a character named Marcus, a senior vice president at a major fintech firm in New York. It is 2026 and Marcus has a standard 401k worth $400,000, which he and his spouse, Elena, have already agreed to split. However, Marcus also has $2 million sitting in a non-qualified deferred compensation plan that pays out only when he leaves the company or reaches age 60. Because this plan is essentially an unsecured promise from the employer to pay Marcus in the future, it is subject to the company's creditors. If the company goes bankrupt, that $2 million vanishes. In a divorce, how do you value an asset that might not exist in 5 years? Elena's legal team might argue for a present value buyout, demanding $1 million in cash today from the sale of the family home to offset her interest in that future $2 million. Marcus, however, might argue that because the asset is risky and taxed at a higher rate upon distribution, it should be valued at a steep discount. This creates a massive valuation gap that leads to the multi-year legal stalemates we see dramatized in American pop culture. Historical trends show that these non-qualified plans are becoming a standard feature of the American upper-middle-class divorce. In 2026, more companies are shifting away from massive base salaries toward these deferred structures to retain talent. For the spouse who isn't the primary earner, this creates a situation of high-stakes financial surveillance. If you don't know, the deferred compensation plan exists because it doesn't appear on a standard 401k statement, you can't ask for your share. This is why forensic accounting has become a booming industry in the U.S. These professionals look for the telltale signs in tax returns, such as Box 11 on a W-2, which can signal the presence of these hidden retirement vehicles. Then there is the 403b, the 401k's sibling for employees of public schools, hospitals, and nonprofits. While a 403b is also a defined contribution plan, the rules for division can be surprisingly different. Many 403b plans are invested in annuities rather than mutual funds. If a plan is tied to an individual annuity contract, dividing it can trigger surrender charges that act like a hidden tax. Imagine a nurse named Karen in Chicago, who has worked for the same hospital for 25 years. Her 403b is an older plan with a high surrender charge annuity. When she and her husband, Leo, divorce in 2026, they find that splitting the account via a QDRO triggers a 7% penalty because the contract is being broken to create a separate account for Leo. This is an example of a potential outcome where the technical structure of the investment vehicle, not the law itself, dictates the loss of capital. Step by step, the division of a 403b requires an extra layer of scrutiny. You must first determine if the plan is an ERISA-governed 403b or a non-ERISA 403b, which is common for governmental or church-related organizations. If it is a non-ERISA plan, the QDRO rules might not apply at all. Instead, you might need a court order that follows the specific, often antiquated, bylaws of that specific organization. This is a trap that catches many general practice divorce attorneys. They spend months drafting a QDRO, only to have a hospital's legal department reject it because their plan doesn't recognize federal QDRO standards. We must also look at the public sector, where the 401k model is often replaced or supplemented by the 457 plan. For police officers, firefighters, and teachers, the 457 plan is a powerful tool because it allows for withdrawals at any age once you leave employment, without the 10% penalty. In a divorce, this makes the 457 plan more valuable than a 401k of the same dollar amount because of its liquidity. In 2026, We are seeing case studies where spouses are fighting harder for the 457 plan than the pension because the 457 represents immediate, accessible cash to restart their lives. Consider the case study of an LAPD officer named Jackson. Jackson has a 457 plan and a traditional city pension. During his divorce, his spouse's attorney realizes that if they take a share of the pension, they have to wait until Jackson retires to see a dime. But if they take a share of the 457 plan, they can potentially access those funds as soon as the divorce is finalized. This leads to a tactical maneuver known as the liquidity play. The non-employee spouse might agree to waive their right to a portion of a larger future pension in exchange for the entire balance of the 457 plan today. In the cultural narrative of the American divorce, this is often the moment where one party secures their freedom fund, allowing them to move out and establish a new household immediately. However, the complexity of the public sector doesn't stop at the 457. We have to address the government pension offset and the windfall elimination provision. These are two federal rules that can significantly reduce the Social Security benefits of someone who also receives a public pension. In a 2026 divorce, these rules can create a massive imbalance. If one spouse is a teacher with a large pension and the other is a corporate worker with a 401k and Social Security, the teacher might end up with their spouse's Social Security being reduced or eliminated upon their death, while the corporate spouse gets to keep the teacher's pension survivor benefits. This is a mathematical puzzle that requires a deep understanding of federal benefits law, and it is a recurring plot point in legal dramas that focus on the unfairness of the system. As we expand on these points, it becomes clear that the division of retirement assets is not a singular event, but a series of interconnected dominoes. If you move one piece, the others shift. In American pop culture, we often see the big win at the end of the trial, but we rarely see the 5 years of tax audits and administrative rejections that follow a poorly planned asset split. We are seeing a historical trend in 2026 where the gray divorce generation is finding that their retirement plans are far more entangled than they realized, leading to a rise in post-decree litigation. But what happens when the assets aren't just in the US? In our increasingly globalized world, what happens when a 401k is being divided alongside a foreign pension or a Swiss bank account? And even more pressing for the modern era, what happens when the retirement account isn't holding stocks and bonds, but is a self-directed 401k holding Bitcoin or private equity in a startup that hasn't gone public yet? The 401k was designed for a simpler time, but the American family of 2026 is anything but simple. We have covered the qualified plans, the non-qualified traps, and the public sector hurdles. But we are about to enter the most controversial territory of all. In the next part, we are exploring the specific world of military retirement and the high-stakes battle over the thrift savings plan. We will see why a military divorce is considered the special forces of family law, and why one mistake in the wording of a decree can lead to a lifetime of lost benefits that not even a judge can fix once the ink is dry. If you think corporate plans are tough, you haven't seen anything until you deal with the Department of Defense. The world of military retirement and the Thrift Savings Plan, or TSP, represents the most rigid and technically demanding frontier of American asset division. In 2026, the intersection of military service and family law is governed by a set of federal statutes that operate almost entirely outside the standard rules of civilian 401ks. While a corporate plan administrator might be flexible with certain QDRO language, the Defense Finance and Accounting Service, or DFAS, operates with a level of bureaucratic strictness that can leave an unwary spouse with nothing. The central pillar of this system is the Uniformed Services Former Spouses Protection Act. This act does not automatically grant a spouse a portion of a service member's retirement. It simply gives state courts the authority to treat military pay as marital property. In American pop culture, we often see the stoic military spouse as a pillar of support, but the legal reality in 2026 is that this support is often litigated down to the 10th of a percentage point. Imagine a character named Tyler, a chief warrant officer in the United States Army who has served for 18 years. Tyler is stationed at Fort Liberty in North Carolina and is going through a divorce with his spouse, Monica. Tyler has a substantial thrift savings plan balance, which is the military equivalent of a 401k. Monica believes that because they have been married for 15 of those 18 years, she is automatically entitled to half of his future pension and half of his TSP. However, under the frozen benefit rule, a massive legislative shift that has fundamentally changed the potential outcomes for military divorces in recent years, the calculation is no longer based on what Tyler is earning at the time he actually retires. Instead, the court must value the benefit as if Tyler had retired on the day of the divorce. If Tyler stays in the Army for another 5 years and gains 2 more promotions, Monica does not see a dime of that increased value. This creates a psychological and financial chasm that we see reflected in modern military dramas, where the timing of a divorce filing becomes a tactical weapon, used by one side to lock in a lower valuation, or by the other to wait for a high-value promotion. The thrift savings plan itself is a unique beast. Unlike a 401k, the TSP does not use a QDRO. It uses a Retirement Benefits Court Order, or RBCO. This is not a distinction without a difference. It is a completely separate legal framework with its own set of mandatory phrases and clauses. If an attorney submits a standard 401k QDRO to the TSP board in 2026, it will be rejected instantly. Step by step, the TSP division process requires a level of precision that is unforgiving. First, the order must specifically state whether the award is a percentage of the account or a fixed dollar amount. Second, it must address the issue of outstanding loans. If Tyler took a $40,000 loan from his TSP to pay for the couple's move or a family emergency, the court must decide if that loan balance is included in the total value of the account during the split. If the order is silent on the loan, the TSP will calculate the division based on the net balance, potentially depriving Monica of thousands of dollars that were marital assets before the loan was taken. Historical trends in 2026 show a rising conflict over the blended retirement system versus the legacy High-3 system. For service members like Tyler who transition to the blended retirement system, their retirement is no longer just a pension. It includes a 1% automatic contribution from the Department of Defense and up to a 5% matching contribution into their TSP. In a divorce, these matching contributions are treated as marital property, but the vesting schedule, the time it takes for the government's money to actually belong to the service member, can be a point of intense litigation. If the divorce happens before the 2-year vesting mark, does the spouse have a claim to that unvested money? The answer is often found in the fine print of federal regulations that most family lawyers have never read. Let's look at a case study involving a Navy commander named Sarah and her husband, James. Sarah has been in the Navy for 22 years. Because they passed the 10-year mark of marriage overlapping with 10 years of service, James qualifies for what is known as the 10-10 rule. This is one of the most misunderstood concepts in U.S. military culture. The 10 out of 10 rule does not determine whether a spouse gets a share of the retirement. It only determines how they receive the money. Because they meet the 10-10 criteria, James will receive his monthly checks directly from DFAS. If they had been married for 9 years and 364 days, James would still be entitled to the money, but he would have to collect it directly from Sarah every month, a scenario that leads to endless post-divorce conflict and collection dramas often seen in televised legal procedurals. In 2026, the 10-10 rule remains a critical threshold that determines the administrative ease and security of a former spouse's financial life. Beyond the pension and the TSP, there is the issue of the Survivor Benefit Plan, or SBP. This is effectively an insurance policy that ensures the pension continues to be paid if the service member dies first. In a 401k divorce, you can designate a successor beneficiary, but in the military world, SBP is a zero-sum game. A service member can generally only have one SBP beneficiary. If Tyler is ordered to name Monica as the SBP beneficiary in their divorce, he cannot provide that same protection to a future wife or children. This creates a massive point of leverage. In 2026, the cost of the SBP premium, which is taken directly out of the retirement pay, is often a central point of negotiation. Does the former spouse pay the premium out of their share? Or is it taken off the top, effectively making both parties split the cost? Imagine if Monica's attorney fails to include a specific deemed election for the SBP within 1 year of the divorce decree. Even if the judge ordered Tyler to provide the benefit, if the paperwork isn't filed with DFAS within that strict 365-day window, the right to that benefit can be lost forever. This is a historical trend of clerical tragedy, where spouses who thought they were protected find themselves with zero income when their ex-spouse passes away. Pop culture focuses on the medals and the deployments, but the true longevity of military service is found in these administrative filings that dictate the next 40 years of a family's financial health. Furthermore, we must address the issue of disability pay. In the U.S., a service member can waive a portion of their taxable retirement pay to receive non-taxable VA disability compensation. From a tax perspective, this is a win for the veteran. However, from a divorce perspective, it can be a disaster for the former spouse. Because VA disability is not considered retiree pay, it cannot be divided by estate court. Historical trends show veterans choosing to maximize their disability rating post-divorce, which effectively shrinks the pie of the divisible retirement pay. In 2026, this has led to the rise of indemnity clauses in divorce decrees, where the veteran agrees to pay the former spouse out of pocket if they ever take an action that reduces the retirement check. The military 401k divorce is a masterclass in the complexity of American federalism. It requires an understanding of the Department of Defense financial management regulations, the Internal Revenue Code, and state-specific family law. As we look at these high-stakes military settlements, we see a microcosm of the larger American struggle. The attempt to fairly divide a lifetime of service and sacrifice into a spreadsheet. But while the military has its own rules, there is an even more volatile asset class that is beginning to disrupt the 401k landscape entirely. We have moved from corporate boardrooms to the front lines of military service, but what happens when the 401k is no longer holding traditional stocks? In 2026, the self-directed 401k has allowed Americans to move their retirement funds into everything from physical gold and raw land to digital assets that exist only on a blockchain. In the next part, we are going to explore the chaotic world of alternative assets in divorce. We will look at the forensic nightmare of valuing a 401k that owns a fractional share of a private jet, a portfolio of NFTs, or a warehouse in a foreign country. If you thought the Department of Defense was difficult to navigate, wait until you see how a court tries to split a retirement account that is locked behind an encrypted private key that one spouse claims to have forgotten. The shift in the American financial landscape towards self-directed retirement accounts has introduced a level of complexity that traditional family law is struggling to contain in 2026. While a standard 401k is usually filled with mutual funds, ETFs, or company stock, the solo 401k and the self-directed IRA have become the preferred vehicles for the modern American entrepreneur. These accounts allow for the inclusion of alternative assets, ranging from residential real estate and private placements to digital currencies. In a divorce, this moves the conversation from simple math into the realm of speculative valuation and forensic investigation. In pop culture, we see the drama of the hidden offshore account, but in the reality of the current U.S. legal system, the drama is often hidden in plain sight within a tax-advantaged retirement shell. Imagine a character named Chloe, a successful digital consultant in Austin, Texas. Over the last decade, Chloe has used a solo 401k to invest in things she understands better than the S&P 500. Her retirement account doesn't just hold cash. It holds the title to a duplex in Nashville and a 15% stake in a Series B tech startup. When Chloe and her husband, Evan, decide to divorce in 2026, the court is faced with a nightmare. You cannot simply use a QDRO to cut a house in half or split a private equity stake that has no public market. This leads to a historical trend of litigation over valuation discounts. Chloe's legal team might argue that the startup stake is illiquid and therefore worth 40% less than its last funding round suggests. Evan's team, pointing to the tech boom of 2025, might argue it is the crown jewel of the marital estate. The step-by-step process of dividing a self-directed 401k holding real estate is particularly grueling. First, the account holder must obtain a certified appraisal of the property within the 401k. However, the 401k itself is the owner, not Chloe. If the court orders Evan to receive half the value, Chloe cannot just take a second mortgage on that duplex to pay him out, because that would violate IRS prohibited transaction rules. Any self-dealing or use of 401k assets to satisfy a personal debt, including a divorce settlement, can trigger a total disqualification of the account. If the account is disqualified, the entire balance becomes taxable in a single year, potentially pushing Chloe into the highest tax bracket and wiping out 40% of the value in federal and state taxes. This is a potential outcome that many DIY divorce seekers overlook until the IRS sends a notice of deficiency. Then we must address the most volatile element of 2026 asset division: cryptocurrency within a retirement framework. Many Americans have moved their 401k rollovers into platforms that allow for the purchase of Bitcoin, Ethereum, or Solana. In a high-stakes divorce, these assets present a unique challenge known as the private key dilemma. Unlike a bank account where a judge can issue a turnover order to a manager, a self-custodied crypto 401k is only accessible via a seed phrase. We are seeing case studies in 2026 where a spouse claims to have lost their hardware wallet in a boating accident, or simply forgotten the 24 words required to access the funds. In American legal procedurals, this is often depicted as a dead end, but the reality is more sophisticated. Forensic blockchain analysts are now routinely hired in U.S. divorce cases. They track the on-chain movement of funds. If Chloe claims she lost access to her crypto 401k in January, but the blockchain shows those specific coins were staked or moved to a different wallet in March, she faces charges of perjury and civil contempt. The court can then use a monetary offset, awarding Evan a larger share of the Nashville duplex to compensate for the lost crypto. This illustrates the high-retention reality of 2026. Digital assets leave digital trails, and the 401k shield does not protect against transparency. Another layer of complexity involves collectibles, held within specialized retirement accounts. While the IRS strictly prohibits most collectibles in an IRA, certain types of gold coins and bullion are allowed. In the cultural zeitgeist of 2026, where inflation concerns have driven many into hard assets, we see divorces where the 401k is essentially a vault of physical gold. The logistics of dividing physical assets held by a third-party custodian require specific QDRO language that accounts for in-kind transfers. Does Evan get half the gold coins, or does the custodian have to sell the gold, potentially at a market low, to send him a check? The transaction fees and the spread on these sales can result in a 3% to 5% loss of capital, just to facilitate the split. We also have to consider the prohibited transaction trap. In a 2026 case study, an individual named Mark had his 401k by a vacation rental in Florida. During the divorce, Mark stayed in that rental for a week to clear his head. Because Mark is a disqualified person in relation to his own 401k, his stay in the property constituted a prohibited transaction. His ex-wife's attorney discovered the stay via a social media post. By reporting this to the court, the attorney effectively turned the 401k into a taxable distribution, significantly reducing Mark's net worth while increasing the immediate tax liability he owed the estate. In pop culture, this is the gotcha moment, but in financial reality, it is a catastrophic loss of tax-advantaged growth that can never be recovered. Beyond the physical and digital, there is the issue of fractional ownership in private aircraft or yachts held through complex 401k structures. While rare, these cases set the precedent for how the U.S. legal system handles the ultra-wealthy. These assets often have high ongoing maintenance fees or capital calls. If a 401k is split, does the non-employee spouse also inherit the obligation to pay for the hangar fees or the pilot's salary? Most QDROs are not equipped to handle ongoing liabilities. This results in clean break settlements where one spouse takes the traditional stocks and the other takes the alternative assets. But as we have seen with the tax blindness of the silver splitters, the person taking the illiquid alternative asset often realizes too late that they have inherited a job, not just an investment. The historical trend of 2026 shows that the more creative a 401k is, the more likely it is to be a source of post-divorce litigation. The American public's fascination with beating the system through self-directed accounts has created a massive backlog in the family court system. We are seeing a move towards special masters, private judges who are experts in ERISA and alternative assets, who are hired specifically to untangle these webs because a standard state judge simply does not have the time or technical expertise to value a 401k that owns a fleet of autonomous delivery drones. We have explored the corporate ladder, the military's rigid lines, and the wild west of alternative assets. But there is one final boundary that is the most difficult to cross: the international border. In an era of remote work and global marriages, what happens when an American 401k needs to be divided with a spouse living in London, Tokyo, or Mexico City? And what happens when the most powerful tool we've discussed, the QDRO, is met with a foreign court that has no idea what it is? The 401k is a uniquely American invention, and that is its greatest weakness when the world gets small. In the next part, we are going deep into international 401k conflict. We will look at the treaty traps, the nightmare of totalization agreements, and what happens when the IRS and a foreign tax authority both want a piece of the same retirement split. If you think your divorce is complicated now, wait until we add a second passport to the mix. The globalization of the American workforce in 2026 has created a friction point between the Internal Revenue Code and international law that many families never see coming. In our previous sections, we treated the 401k as a domestic asset, safely tucked away in US-based servers. But imagine a scenario where a marriage spans across oceans. This is no longer just a plot point for a high-budget spy thriller or a romantic drama set in Paris. It is a daily reality for thousands of U.S. citizens and green card holders. When an American 401k is involved in an international divorce, the Qualified Domestic Relations Order, our reliable tool for the last 6 parts, suddenly hits a brick wall at the border. The fundamental problem is that a QDRO is a creature of United States federal law, specifically ERISA. Foreign courts in the United Kingdom, Japan, or Germany have no jurisdiction over a U.S. plan administrator, and conversely, a U.S. plan administrator has no legal obligation to follow a foreign divorce decree. This creates a jurisdictional vacuum that can lead to potential outcomes where a spouse is awarded a share of a 401k by a foreign judge, but the U.S. financial institution refuses to move the money. Historical trends show that this often results in a secondary legal battle in U.S. courts just to domesticate the foreign order, a process that can double the legal fees and take years to resolve. Imagine a character named Sophia, a marketing executive who moved from New York to London 3 years ago. She is a U.S. citizen with a 401k worth $800,000 held at a major American brokerage. She is divorcing her husband, Alistair, a British national. They are filing for divorce in the UK. The British court, applying its own standards of fairness, decides Alistair should receive 50% of the 401k. However, the American brokerage tells Sophia that they cannot recognize the UK court order. They require a QDRO issued by a U.S. state court. Now Sophia and Alistair are trapped in a stalemate. Alistair cannot get the money because he doesn't have a U.S. order, and Sophia cannot easily get a U.S. order because she is no longer a resident of any U.S. state. This is the international jurisdictional trap. Step by step, the solution to this in 2026 involves a complex legal maneuver known as a mirror order. First, the parties must finalize their divorce in the foreign country. Second, they must hire a U.S.-based attorney to initiate a special proceeding in a U.S. state court, usually the last state where they lived, to recognize and enforce the foreign judgment. Only after the U.S. judge signs a domestic order can the QDRO be drafted and sent to the 401k administrator. The administrative costs of this process frequently exceed $20,000, which can represent a significant percentage of the account balance itself. Then we must address the issue of tax treaties and the IRS. The United States is one of the few countries that taxes based on citizenship, not just residency. If a foreign spouse like Alistair receives a distribution from a U.S. 401k, the IRS may view this as U.S. source income. Under the default rules, the plan administrator might be required to withhold 30% of the distribution for federal income tax. While a tax treaty between the U.S. and the UK might reduce this rate, the burden of claiming treaty benefits falls entirely on the foreign spouse. Case studies from 2026 indicate that many foreign spouses, unaware of these requirements, see nearly a third of their settlement vanish into IRS withholding, which they then have to fight to recover through a complex 1040nr tax filing. Conversely, imagine if the assets were flipped. Imagine an American citizen, Robert, living in Mexico, who is divorcing a Mexican national. Robert has been contributing to a Mexican retirement account, such as an Afore. When the Mexican court divides this account, the IRS may not recognize the transfer as tax-free. Under U.S. law, a foreign retirement account is often treated as a grantor trust or a passive foreign investment company, or PFIC. If the Mexican court orders the account split, the IRS might view the transaction as a taxable event for Robert, even though the money never entered the United States. This is a potential outcome of the totalization agreements and the Foreign Account Tax Compliance Act, or FATCA, which forces foreign banks to report the holdings of U.S. citizens to the Treasury. In American pop culture, we often see the jet-set lifestyle portrayed with envy, but in the context of a 401k divorce, it is a logistical minefield. We see this reflected in current 2026 media where characters are warned that moving abroad might be the most expensive financial decision they ever make. The complexity scales with the number of jurisdictions involved. If a couple lived in Singapore, then the US, and finally retired in Spain, they might have 3 different retirement systems competing for the same dollars. There is also the matter of currency risk. A 401k is denominated in US dollars. If a settlement is reached in 2026 based on a euro valuation, but the QDRO takes 6 months to process, a shift in the exchange rate can radically change the value of the settlement. Let's look at a case study of a tech worker in Seattle who was divorcing a spouse in Japan. The settlement was calculated when the yen was weak. By the time the funds were actually transferred and converted into yen, the exchange rate had shifted by 15%. The spouse in Japan received significantly less purchasing power than they had bargained for, leading to a new round of litigation over who should bear the cost of the currency fluctuation. Furthermore, we must look at the impact of the 401k loan in an international context. If a U.S. worker took a loan against their 401k to buy a villa in Tuscany and then divorced, the property is in Italy but the debt is in the U.S. A U.S. court has no power to force an Italian bank to change the title of the villa, and an Italian court may not recognize the 401k loan as a valid lien on the property. This results in imbalanced settlements where one spouse gets the clean U.S. assets, and the other is left with a foreign property that is functionally impossible to sell or refinance because of the cross-border debt. The historical trend in 2026 is that international families are increasingly turning to prenuptial and postnuptial agreements that specifically address the 401k. These agreements often include choice of law clauses, where both parties agree that no matter where they live, their retirement assets will be governed by the laws of a specific U.S. state like Delaware or New York. However, even these agreements are not a shield. Many foreign countries view U.S.-style prenups as contrary to public policy and may refuse to enforce them, especially if they believe the agreement leaves one spouse in a position of financial hardship. As we examine these global conflicts, it becomes clear that the 401k is a tether that keeps citizens tied to the U.S. legal system long after they have left American soil. But while the international border is a major obstacle, there is an even more intimate boundary that is currently being redrawn in the American legal system. We have talked about marriage and divorce, but what about the millions of Americans in 2026 who are in marriage-like relationships but never signed a legal contract? What happens to the 401k when a domestic partnership or a long-term cohabitation ends? Is there such a thing as a QDRO for a common law breakup? In the next part, we are going deep into the gray area of non-marital splits. We will look at the rise of palimony in the retirement age, the specific states that are expanding 401k rights to unmarried partners, and the high-stakes world of beneficiary designations, where a single unchecked box can override a 20-year relationship. If you think the law only cares about people with a marriage license, you are about to see how the definition of family is being legally re-engineered in 2026. The legal landscape of 2026 has witnessed a massive shift in how the American justice system views the accumulation of wealth outside the traditional confines of a marriage certificate. For decades, the 401k was seen as a fortress accessible only through the gate of legal matrimony. However, as cohabitation rates in the United States have reached all-time highs, particularly among the millennial and Gen Z demographics, a new body of law is emerging to address the division of retirement assets when long-term, unmarried partners part ways. In American pop culture, we often see the drama of the common law marriage, but the reality is that only a handful of states, such as Colorado, Iowa, and Texas, still formally recognize common law marriage. In the rest of the country, if you are not legally married, the QDRO tool we have discussed is generally unavailable. This creates a high-stakes financial cliff for the non-account holding partner. Imagine a character named Maya, a freelance graphic designer in Seattle. It is 2026, and Maya has lived with her partner Liam for 18 years. Liam is a senior executive at a major aerospace firm with a 401k valued at $1.5 million. Maya has spent nearly 2 decades supporting Liam's career, moving for his promotions, and managing their shared household while maintaining a modest income of her own. When their relationship ends, Maya discovers a cold, hard truth. Because they never married, she has no statutory right to a single cent of Liam's 401k. Under federal ERISA law, Liam's 401k is his separate property. There is no judge in a standard family court who can force a plan administrator to split that account for a non-spouse without a legal marriage. This has led to the rise of the palimony lawsuit, or more accurately in 2026, the Marvin action. Named after the landmark California case Marvin versus Marvin, these are civil contract claims rather than family law cases. To get a share of that 401k, Maya must prove that an implied or express contract existed between her and Liam to share their assets. Historical trends in 2026 show that these cases are notoriously difficult to win. They require mountains of evidence, emails, shared bank statements, testimony from friends, to prove that Liam promised to share his retirement with her. Even if Maya wins a civil judgment for $750,000, she cannot use a QDRO. Liam would have to withdraw the money, pay the income taxes and the 10% early withdrawal penalty himself, and then hand her the remaining cash. This is a potential outcome where a $1.5 million retirement account is decimated by taxes and penalties just to satisfy a civil settlement. The step-by-step reality of these non-marital splits in 2026 often centers on the beneficiary designation form. This is the one area where the law is ruthlessly simple. ERISA mandates that if you are married, your spouse is automatically the beneficiary of your 401k, unless they sign a written waiver. But if you are unmarried, the name on that digital form is the only thing that matters. We are seeing case studies where individuals have lived with a partner for 30 years, but because they never updated their beneficiary form from a high school sweetheart or an estranged sibling, their long-term partner is left with nothing upon their death. In 2026, the beneficiary designation is being called the death QDRO in legal circles because it is the final, unappealable word on who gets the money. Consider the case study of a tech worker named Carlos in Austin. Carlos had a 401k worth $900,000. He lived with his partner Derek for 12 years. Carlos always told Derek the money was for their collective future. However, Carlos never updated his beneficiary form, which still listed his mother. When Carlos unexpectedly passed away in early 2026, the plan administrator was legally required to pay the entire $900,000 to the mother. Despite Derek's years of domestic partnership and the existence of a will leaving everything to him, federal ERISA law trumped the state will. The mother received the funds, and Derek was left with zero legal recourse to claim the retirement assets. This is the ERISA preemption trap that continues to shock the American public. In response to these tragedies, we are seeing a historical trend of states creating domestic partnership or civil union registries that mimic the protections of marriage. In states like California, Oregon, and Washington, a registered domestic partner may have rights similar to a spouse when it comes to asset division. However, there is a massive catch. While the state recognizes the partnership, the federal government and many private 401k plans may not. This creates a split jurisdiction nightmare. A state judge might order the 401k to be divided, but the plan administrator might reject the order because the partner does not meet the federal definition of a spouse. In 2026, this is resulting in equalization settlements, where the partner is awarded a larger share of the non-retirement assets, like the house or the brokerage account, to compensate for the fact that the 401k cannot be legally touched. Another layer of this re-engineered family definition is the multi-partner household, or polyamorous union, which is beginning to enter the U.S. legal conversation in 2026. In cities like Somerville and Cambridge, Massachusetts, domestic partnership ordinances have been expanded to include more than 2 people. This creates an unprecedented mathematical and legal puzzle for the 401k. If 3 people have lived as a family unit for a decade and the relationship dissolves, how does a court divide a 401k that was built by the contributions of 1 but supported by the labor of 3? Currently, there is no federal framework for a QDRO. This is the new frontier of American litigation, where the cultural reality of family is outpacing the legislative ability to track it. Pop culture is just beginning to catch up to this complexity. Shows that once focused on the simple cheating spouse tropes are now diving into the financial survivor stories of people left behind by the lack of a marriage license. We see characters navigating the cohabitation agreement, which in 2026 has become as essential for unmarried couples as a prenup is for the wealthy. These agreements explicitly state how 401k contributions will be handled if the relationship ends. They are the private law that fills the gap where public law fails. Without such an agreement, the non-account holder is essentially gambling on the goodwill of their partner. Furthermore, we must address the silver cohabitants, older Americans who choose to live together without marrying to avoid the widow tax or the loss of Social Security benefits from a previous spouse. For this group, the 401k is their primary source of health and housing security. In 2026, we are seeing a rise in retirement trusts, where unmarried seniors move their assets into a shared entity to ensure their partner is protected. However, moving a 401k into a trust is not a simple task and often requires first rolling the 401k into an IRA, which can change the creditor protection status of the money. The division of the 401k in 2026 is no longer a simple binary of married or divorced. It is a spectrum of legal statuses, each with its own traps and requirements. We have seen how the lack of a marriage license can turn a 7-figure retirement into a zero-sum game. But what happens when the marriage is perfectly legal, but the money is gone before the divorce is even filed? What happens when one spouse uses the 401k to fund a secret life, a failing business, or a series of risky investments that the other spouse knew nothing about. We have covered the international borders and the non-marital gray areas. But we are now moving into the heart of the financial infidelity era. In the next part, we are going to look at the 401k heist. We will explore how fraudulent joinder, forged waivers, and hidden loans are used to gut retirement accounts from the inside out. We will see how forensic accountants use the 2026 digital trail to reconstruct ghost accounts, and what the law does to a spouse who tries to spin the evidence before the judge can sign the order. If you think your money is safe just because it's in a 401k, you haven't seen how easy it is for a partner with your password to make it disappear. In the digital-first economy of 2026, the 401k is no longer just a retirement account. It has become the primary target for what sociologists call financial infidelity. While physical affairs dominate the headlines of tabloid magazines, the quiet, methodical draining of a retirement account is often the more devastating betrayal. In the United States, historical trends show that nearly 43% of adults in committed relationships admit to keeping financial secrets. And in the high-stakes environment of a failing marriage, these secrets often involve the unauthorized liquidation of marital assets. Pop culture frequently portrays the hidden bank account, but the modern reality is far more sophisticated. We are seeing a rise in the 401k heist, where a spouse uses their administrative access to gut an account before a divorce filing can trigger a legal freeze. Imagine a character named Elena, a high-level marketing director in Chicago. Elena and her husband, Mark, have been married for 15 years. Mark has always handled the boring paperwork, including the logins for their shared financial portal. In early 2026, sensing that Elena is preparing to file for divorce, Mark initiates a series of 401k loans and hardship withdrawals. Because the vast majority of 401k plans in the U.S. do not require spousal consent for a loan, a shocking regulatory gap highlighted by the GAO in 2026, Mark is able to pull $50,000 out of the account in a single week. He claims the money was for home repairs that never happen, but in reality he is moving the cash into a private digital wallet. By the time Elena files the paperwork and a status quo order is issued, the account balance has been slashed, and the cash is nowhere to be found. Step by step, the U.S. legal system handles this through a process called a dissipation of marital assets claim. When Elena's attorney discovers the missing funds during the discovery phase, they don't just ask for the money back. They hire a forensic accountant. In 2026, these professionals use AI-driven tools to trace the digital trail of 401k distributions. If they can prove that Mark spent the money on non-marital purposes, such as a secret vacation, gambling, or hiding it for later, the court can use a monetary offset. This means the judge will calculate the marital estate as if that $50,000 were still there. If the remaining 401k is worth $200,000, instead of splitting it $100,000 each, the judge might award Elena $125,000 and Mark only $75,000 to repay her share of the stolen funds. However, the heist isn't always about taking cash out. Sometimes it's about the fraudulent waiver. Under federal law, if a participant wants to change their primary beneficiary from their spouse to someone else, the spouse must sign a notarized waiver. In 2026, we are seeing a historical trend of forged digital signatures. Using sophisticated software, a spouse can replicate a partner's signature on a PDF and submit it to the plan administrator. If the spouse passes away before the divorce is finalized, the survivor discovers they have been erased from the 401k entirely. Case studies from recent years show that while plan administrators have a fiduciary duty to protect assets, they are often ill-equipped to detect high-quality forgeries. The legal battle to overturn a fraudulent beneficiary change can take years of litigation in federal court under ERISA, often costing more than the value of the account itself. Another layer of 401k fraud involves the phantom loan. In this scenario, a spouse takes a loan from the 401k and then intentionally stops making the payroll deductions to pay it back. When the loan defaults, the IRS treats the outstanding balance as a taxable distribution. For the high-earning spouse, this is a calculated move. They get the cash today, and they force the tax bill to be shared as a marital debt during the divorce. In 2026, courts are becoming increasingly aggressive toward this tactic. If a judge determines a loan default was a deliberate attempt to devalue the marital estate, they can designate the entire tax liability and the 10% penalty as the separate debt of the defaulting spouse. In American pop culture, we see this played out in shows like The Lincoln Lawyer or Succession, where the paper trail is the ultimate weapon. But for the average viewer, the real lesson is the importance of digital sovereignty. We are moving into an era where account security is a form of divorce protection. If you do not have your own login to your spouse's 401k portal, or if you haven't reviewed a summary plan description in years, you are effectively flying blind. The 2026 financial landscape rewards the auditor spouse, the one who keeps copies of every statement and monitors the last login date on shared accounts. Consider the case of the vanishing match. Some employers offer a profit-sharing component to their 401k that only vests at the end of the year. We have seen case studies where a spouse intentionally delays a divorce filing until January 2nd just to ensure they capture the final year of the employer's contribution, or conversely, rushes a filing in December to prevent the other spouse from having a claim to that same bonus. In the U.S., the timing of the date of separation is the most litigated second of the entire divorce process because it acts as the shutter that stops the clock on marital growth. As we look at these 401k heists, it becomes clear that the retirement account is the ultimate scoreboard of a marriage's financial trust. When that trust is broken, the 401k is often the first thing to bleed. But while fraud and theft are the most dramatic ways to lose a retirement, there is a much more common, much more silent way that millions of Americans lose their 401k value every single year. And it has nothing to do with their spouse, and everything to do with the market trap. We have mastered the laws, the borders, and the frauds, but we have not yet talked about the volatility war. In the final part of this masterclass, we are going to look at the market crash divorce. What happens when you agree to a settlement on Monday, and the market drops 20% on Tuesday? We will explore the flash crash QDRO, the specific clauses that protect you from a ghost portfolio, and how to ensure that when the dust settles, you aren't left holding a bag of empty promises. This is the conclusion of our deep dive, and it is the most important financial lesson you will ever hear. The volatility war is the final and perhaps most ruthless stage of the 401k divorce. In the American financial landscape of 2026, the interval between the day a couple agrees to a settlement and the day the funds actually move can be a period of extreme vulnerability. Most people treat a settlement agreement like a static snapshot in time, but the market is a living, breathing entity. If your legal documents do not account for market fluctuations during the administrative processing period, you are essentially gambling with your future. This is where the concept of the ghost portfolio comes into play. A situation where the value of the assets you were awarded exists on paper in the divorce decree, but has vanished by the time the plan administrator executes the transfer. Imagine a character named Thomas, a middle manager in Denver who is finalizing his divorce in the spring of 2026. Thomas has a 401k worth $500,000, largely invested in high-growth tech stocks. His spouse, Rebecca, agrees to a settlement where she receives a flat dollar amount of $250,000. On the day the judge signs the order, the market is at an all-time high. However, because of the bureaucratic delays we discussed in earlier parts, the QDRO drafting, the plan administrator's review, and the standard 30-day hold period, the actual transfer doesn't trigger for another 10 weeks. During those 10 weeks, a sudden geopolitical event causes a 15% market correction. The total account value drops to $425,000. Because the order specified a fixed dollar amount of $250,000, the plan administrator must still fulfill that specific number for Rebecca. Thomas is left with only $175,000. In this potential outcome, Thomas has borne 100% of the market risk for an asset that was supposedly split 50-50. Historical trends in 2026 show that the U.S. courts are increasingly moving toward percentage-based awards with pro rata gains and losses to prevent this exact scenario. A pro rata clause ensures that both parties share in the growth or the decline of the account from the date of valuation until the date of distribution. If Thomas and Rebecca's order had been drafted with this language, Rebecca would have received 50% of whatever the account was worth at the time of transfer, meaning they both would have taken a proportional hit from the market correction. Step by step, protecting yourself from the volatility war requires 3 specific actions. First, defining the exact valuation date. Second, specifying whether the award is a fixed sum or a percentage. And third, explicitly stating who receives the earnings and losses on the awarded share during the pendency of the QDRO. We must also examine the case study of the flash crash QDRO. In the summer of 2026, the rise of algorithmic trading has made the American stock market prone to rapid intraday swings. Imagine if a 401k transfer is triggered during a morning dip, but the market recovers by the afternoon. Depending on the plan's specific liquidation policies, one spouse could lose thousands of dollars in purchasing power simply because of the hour the trade was executed. This has led to a rise in the use of stable value funds during the divorce process. Many sophisticated legal teams now include a provision in the settlement that requires the 401k participant to move the portion of the funds earmarked for the ex-spouse into a low-risk money market or cash equivalent fund within the 401k, as soon as the decree is signed. This effectively freezes the value and shields both parties from a ghost portfolio scenario. The psychological toll of these market-driven imbalances is a recurring theme in 2026 American pop culture. We see it in prestige dramas where a character's entire retirement strategy is undone not by a legal mistake, but by a ticker tape. This brings us to the final and perhaps most overlooked aspect of the 401k deep dive: the lost opportunity cost. When a 401k is split, you aren't just losing half your current balance, you are losing half of your future compounding power. If you are 45 years old and lose $200,000 of your 401k in a divorce, you haven't just lost $200,000. Assuming a 7% average annual return, you have lost the $800,000 that money would have become by the time you reach 65. This is the reality that shapes the American retirement crisis of the late 2020s. For the silver splitters, those divorcing in their late 50s or early 60s, there is simply not enough time for the remaining half of the 401k to compound back to a sustainable level. This has resulted in a historical trend where divorced individuals are staying in the workforce an average of 5 to 7 years, longer than their married counterparts. They aren't working because they want to, they are working to fill the hole left by the QDRO. As we conclude this masterclass, we must address the ultimate question. How do you move forward after the 401k is split? In 2026, the answer lies in the immediate utilization of catch-up contributions and the strategic use of health savings accounts or HSAs as a secondary retirement vehicle. If the divorce settlement was handled correctly, the spouse receiving the funds via QDRO has a clean slate. They can roll those funds into a new IRA and begin their own compounding journey. For the spouse who provided the funds, the focus shifts to aggressive tax-deferred growth to rebuild the principal. We have traveled through the history of the 401k, the technical minefield of ERISA, the rigid protocols of the military, the chaos of alternative assets, the jurisdictional traps of international law, and the dark alleys of financial infidelity. What we have discovered is that the 401k is not just an account. It is a legal and cultural battlefield that represents the sum total of an American's labor and their hope for the future. In pop culture, the divorce is the end of the story. In reality, the 401k split is the beginning of a new financial chapter that requires more vigilance, more education, and more precision than the years of accumulation that preceded it. The American pop culture obsession with the 401k divorce is ultimately an obsession with the fragility of the middle class. It is a realization that 40 years of work can be reallocated in 40 minutes by a judge's pen. But armed with the data, the case studies, and the step-by-step details provided in this deep dive, you are no longer a passive observer of your own financial fate. You understand that a QDRO is more than paperwork. It is a shield. You know that a tax treaty is more than a footnote. It is a lifeline. And you recognize that the 401k, for all its complexity, remains the most powerful tool for wealth building and wealth protection in the modern world. This concludes our 10-part masterclass on the 401k divorce in American pop culture. We have pulled back the curtain on every secret the system holds. But while the 401k is the largest asset for most, it is not the only one. There is another financial giant looming in the background of every American household, one that is even more misunderstood and even more prone to disaster during a domestic transition. In our next deep dive series, we are moving from the 401k to the roof over your head. We will explore the high-stakes world of the divorce mortgage. We are going to look at the assumability trap, the equity-rich, cash-poor dilemma, and why your credit score might be the first casualty of a house you no longer live in. If you thought the 401k was a battle, wait until you see what happens when the bank gets involved in your breakup. The masterclass continues in the next series.